Cut. Hi everyone. We are going to give a group presentation on the business and corporation law on the case analysis of Forrest versus ASIC. In this, the case arose in the year 2005 to 2004 to 2005, where FMG got a project doing mining activities to export the ore of iron in Western Australia. This project was also called as Pilbara Infrastructure Project. This project was projected to connect the mine to the port through the network of railway, port headland, and the region of Pilbara Hill. In early 2004, Forrest and FMG entered into the negotiation process with the three Chinese companies, and they implemented similar three agreements on the framework with these three Chinese companies to ensure the construction of the project. At the time of agreement, Forrest was the CEO and chairman of the FMG. During the duration of framework agreement, FMG announced to the Stock Exchange of Australia that the company has entered into a collective agreement and also made a media release in the context of agreement. The statement of FMG in media export was seen as representing that the agreement framework imposed the obligation on Chinese company to finance, build and transfer each required infrastructure to complete the project. Because of the statement of FMG, the share price of the company has reached to $1.93 from 0.59 cents. And also, due to the agreement framework, the involved Chinese company are not legally obligated. Because of this article, the share price of FMG were gone in a negative direction. After a year, ASIC filed a case against Forrest and FMG, and the rest of the part that will be argument made by plaintiff and defender we're gonna talk with my friend Piso Bandhu Kimire.
Thank you, Viraz. Now I'm going to give my presentation on argument made by plaintiff. Our case study is about Forrest versus ASIC, which arose in the year 2004 to 2005. ASIC alleged that the statement of FMG was based on deceptive conduct because it contravened the Section 52 of Trade Practices Act 1974 and Section 104 years. ASIC was also alleged that FMG violated the Section 6742 of Act because they released an incorrect statement to public. This was also against Forrest personally because ASIC believed that Forrest was personally involved in the negotiation process. Therefore, it was also involved in the contraventions of Section 6742 and Section 1041 years of the Act. Therefore, it was also contravened Section 6742A. And on the other hand, Forrest was also liable towards its disclosure obligation, and the case described that Forrest did not fulfill associational liability. ASIC was against Forrest because Forrest breached the director's duties related to diligence and duties of due care that was just against the Section 181 of Act. ASIC, the proceedings related to civil against Forrest and Fortescue by allying that during the announcement, the statement of FMG in the term of framework agreement was binding. That means there was an intention to do deceptive or misleading conduct. The FMG and Forrest both were failed to disclose the information to inform the market about the possible consequences of the agreement frameworks and their effects and implications to involve parties and other stakeholders. Therefore, the organization and its director both did not perform their duties of continuous disclosure and obligations. As a CEO of a company, it was the responsibility of Forrest to present the real information to the stakeholders of the company. That was an example of breaching of directors' duties, which have defined in the Corporation Act 2001 of Australia. Now I'm going to tell about argument of defender. Forrest also footed the statutory defense on the basis of Corporation Act 2001, which claimed that the companies should have ensured the fulfillment of each law to take reasonable steps for achieving compliance. Also performed the duties related to the obligation of continuous disclosure on the behalf of FMG, and was entitled to the protection of the rules related to the business related to judgment. Now I would like to call my friend Sanju for further presentation.
Thanks, Vishnu. Today I'm going to do the presentation about the judgment of court and the deceptive and the misleading conduct. Judgment of court, and it's under this we are going to talk about the initial trial. This case was initially heard by the trial judge of the federal court, who was rejected in the case against Forrest and FMG in December 2009. The court stated that the statement of FMG did not contravene section 1041H because of the entire statement was showing the expression of company which have used by the Forrest and FMG honestly during the negotiation process with Chinese company. Further, the trial judge felt that there was no additional information which can suggest that the statement used by FMG was incorrect. During the trial, ASIC alleged FMG that the entire communication conducted in the media was based on dishonesty, which has only deceptive or misleading nature to deceive or mislead. The trial judge was considered a point that the Forrest and FMG both knew about the reality of the agreement framework, and they did not reveal the legal consequences of agreement and the impact of Chinese company. The agreement framework was also included several subject areas to make further agreement and contract before reaching the binding commitments. It's by the Hill and Thomas 2015. The trial court found the company did not contravene section 674 also. ASIC made an appeal against the decision of trial judge by arguing that the judge during trial mistook an entire finding in the context of statement made by FMG in media. The full federal court accepted the appeal of ASIC and overturned a decision made by the trial court. Further, Forrest and FMG appeared in the High Court and reversed the decision made by the full court, Hill and Thomas 2015. In this context, High Court held that the statement related to the announcement and accurately reflected the terms used in the framework agreements, and the terms such as binding contract was used to show the parties were entered into a contract and they have intention to make legally enforceable binding contract. Under the deceptive and misleading conduct. As per the descriptive and the argument, High Court agreed that the conduct of FMG was just informative and did not mislead. Legal consequences related to the framework agreements to define what the statement is related to the framework against. The court was also focused over the consequences to get the answer of the question whether the statement they call is binding contract or not. According to the High Court, in statement reflected the real effect of the agreement related to the framework. Because of the reason, High Court rejected the submission of ASIC, which also intended to the whole target audience will conclude the framework of agreement empowers and binds FMG for forcing the Chinese company. Now I'm gonna hand over to my friend Prasant.
Thank you, Ms. Sanju. Now I am going to discuss about continuous disclosure, liability of forest, link between duties of director with the liability of company, and undermine the negligence function. As per the finding related to section 1041H, court overturned the liability related claim in the context of FMG, which was related to the breach of obligation, which has been described under the section 674 of the Corporation Act. Liability of the forest. In terms of the forest liability, High Court stated that the responsibility of forest depends upon the demonstration of ASIC towards the contraventions of FMG. Since ASIC did not able to demonstrate the fact related to the conversation of section 674 and S141H, due to this the liability of forest cannot be made out. The uttermost aspect of this case is the link between duties of director and the liability of the company. The High Court stated in the judgment of the forest liabilities directly depends on the liability of FMG. So court did not address the liability of forest for the breach of the director's duties in the absence of financial loss, which will be suffered by the organization. Thank you.